I call the Planning Commission meeting for October 17th, 2024 to order. We'll begin with the pledge. Pledge
Allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Jackie, will you call the roll?
Mr. Rossetti,
Excuse.
Mr. Tiedemann,
Here.
Mr. Varga,
Here.
Mr. Crocker,
Here.
Mr. Haddon,
Here.
Mr. Perkovich,
Here.
Mr. Cook.
Here, I'll entertain a motion for the approval of the minutes from the regular meeting, September 26, 2024.
So moved.
Second.
Jackie, please call the roll.
Mr. Tiedemann,
Yes.
Mr. Varga,
Abstain.
Mr. Crocker,
Yes.
Mr. Haddon,
Yes.
Mr. Perkovich,
Yes.
Mr. Cook.
Yes. On tonight's agenda, we have 3 public hearings, and we will follow this format. First, the applicant will have the opportunity to explain what they would like to do at a particular location. Second, anyone wishing to speak in favor of this proposal will be given the opportunity. Finally, anyone wishing to speak in opposition will be afforded the time to do so, or some people may just have questions, and we'll try to get those answers. And with that, we have a conditional use permit to allow personal care services as a similar use at 8500 Station Street, Unit 282. Is that applicant here? Please come up, give us your name and address, and tell us a little bit about what you want to do.
My name's Jake Ross. The address is 8500 Station Street, Mentor, Ohio. I currently have a tattoo studio at that location, and I was unaware that I wasn't zoned correctly for that. And I'm just here to be zoned correctly.
Thank you. Just hold on one second. Is there anybody here wishing to speak in favor of this proposal? Anybody wishing to speak against this proposal? This public hearing is closed. Kathy, anything from the administration?
This is a very familiar request. We saw one just about 2 months ago. And I did verify with the General Health District that they are properly licensed, and so we have no other concerns.
Thank you. Anything from the commission members? With that, I'll entertain a motion.
Motion to approve with the 2 conditions.
Second. Jackie, please call the roll.
Mr. Tiedemann,
Yes.
Mr. Varga,
Yes.
Mr. Crocker,
Yes.
Mr. Haddon,
Yes.
Mr. Perkovich,
Yes.
Mr. Cook.
Yes. Thank you.
Thank you.
Thank you.
With that, number 2, we have a conditional use permit to allow vehicle sales, service, and leasing at 777 Menor Avenue. Is that applicant here? Please come up, give us your name and address, and tell us a little bit about what you'd like to do on Menor Avenue.
Hello, my name's Scott Raymond. We're looking at property 777 Mentor Avenue, and we're looking to open up an indoor golf cart retail store along with scooters and other LSV vehicles.
Thank you. Is there anybody wishing to speak for this proposal? Anybody wishing to speak against this proposal? This public hearing is closed. Kathy, anything from the administration?
Mr. Chairman, we have 6 conditions noted. The applicant just indicated that they have more than golf cart sales, so maybe he could elaborate specifically, because condition number 2 indicates a recommendation for identifying only golf cart sales.
So what we carry is basically majority are electric golf carts, but we do have a line of scooters that we carry that are 50cc scooters that require no motorcycle license. Both basically recreational use vehicles is what we call them.
Thank you. Anything else, Kathy?
I guess I have a question for the law department. With respect to Chapter 375 of the Mentor Code of Ordinances, would the scooters fall in line with that as well? No operation on city streets?
I have no idea what the nature of these scooters are, whether they're street legal or not. We don't have that information in front of us.
In other municipalities where we sell these out there, street legal if you're 16 and over. It does not require a motorcycle license.
Is it a moped?
It's like a Vespa. Have you seen the Vespas?
I don't know. I'm not versed on these.
Mr. Chairman, I mean, that's, now I have a question. You don't need a motorcycle license. What kind, if you're on the street, don't you need some kind of license?
Well, if you have a vehicle license, you're legalized to ride them. But they have another brand that we do not carry that are 150 cc's that require a motorcycle license. So that's why there's two classifications for them. Being 50 cc's does not require the motorcycle license, but as long as you're 16 years old with a license, you can drive them.
Okay.
Mr. Chairman?
If I may,
Sorry,
it
go
seems
ahead.
like a material change to the application, and that's very unfair to the administration, all of its various departments, including police and fire, to try to make a decision based on this additional aspect of the retail sales. So, two options, I think, for the commission. One, to table it, allow for a supplemented application to come in, allow for the administration to properly review that and have some additional discussions with the applicants. They have all the information they need to properly present this to the commission. Or proceed as presented, in other words, retail sales of golf carts to the exclusion of any other vehicles. The applicant can, if that were granted, then the applicant can always come back and seek an amendment for some change in that inventory sales. Thank you.
If I
Think
can
so.
speak, we could honestly go without having the scooters at the store, to be honest with you. It's just another brand that we decided to pick up about a month ago at the other two locations we carry. So we're just trying to keep consistency throughout the stores. But if it puts a wrinkle in the water, I mean, we have no problem not carrying them there.
Thank you. Is there anything else from the commission members? Okay.
Mr. Chairman,
Mr. Tito.
can I ask a quick question? Test driving, what do you do since we can't drive these things on the road? What do you plan on doing?
Most dealerships do not allow test driving.
Okay,
So that's really not an issue for us.
Okay.
You know, they're indoors displays. It's not something we keep outdoors. You know, it's basically you come in. It's like when you buy a four-wheeler at an ATV store. You know, you don't go out and test drive it through the parking lot and the streets on it. Most people understand what they're purchasing at the time.
thank you. Thank you.
Thank you. Is there
Mr.
anything-
Chairman?
Mr. Crocker.
Question for the applicant. You've looked through the proposed conditions. Condition number 4 states you can only have 4 vehicles outside on display, and then you bring those in every night, and you're okay with that?
Absolutely.
Okay.
Yes.
Mr. Chairman,
Mr. Hart.
does the police, did they review this?
Yes.
Because I don't want to tell tales out of school, but there's somebody on my street that drives one of these carts up and down the street on a regular basis, and no one seems to care. No, I'm not turning anyone in. But I'm just concerned about what the police actually, I mean, how do they, are they're going to keep track of this?
Mr. Zeman.
Yes, it's a lawful product that they want to sell, obviously. Now, what people may do with that lawful product could run afoul of our traffic laws. So, are people who unlawfully operate golf carts within the statutory meaning of that term cited in the city of Mentor? Yes, they are. Some things that look like golf carts are actually street legal, but you certainly encourage everyone. Just because it might have a license on it doesn't per se mean that it's actually street legal in the city of Mentor. Nor do our police department inspect these vehicles for that legality. That would go through the Ohio State Patrol. So before anyone has any type of, vehicle that's golf cart-ish, shall I say, we certainly encourage them to make sure that they're in full legal compliance prior to operating them on the streets. Because there are some legal nuances relative to weight and equipment and other issues there, as well as the operable speed. So the bottom line is, yes, our police are diligent about this. Whether or not someone is operating on your street unlawfully, certainly encourage them not to. They'll get caught eventually.
Well, and I thought just having that statement was useful for the general public knowledge in the meeting. Thank you.
Is there anything else? With that, I'll entertain a motion.
Move to approve with the 6 conditions.
Second,
Jackie, please call the roll.
Mr. Tiedemann?
yes.
Mr. Varga?
Yes,
Mr. Crocker?
Yes.
Mr. Haddon?
Yes.
Mr. Perkovich?
Yes.
Mr. Cook?
Yes. Thank you.
Thank you, guys. I appreciate it.
Number 3, we have a conditional use permit to allow a vehicle repair shop at 8415 Station Street. Is that applicant here?
yes,
Please give us your name and address and tell us a little bit about what you'd like to do.
Sure. Rick Osborne Jr. and Jamie Pilla, Menor Nissan, looking to reopen the former Tuffy Muffler facility and use it for auto repair.
Thank you. Is there anybody wishing to speak for this proposal? Anybody wishing to speak against this proposal? This public hearing is closed. Kathy, anything from the administration?
Mr. Chairman, we have 10 conditions, and I understand that Mr. Osborne might have some information with regard to the access agreement that's already on site. Could you talk about that a little bit?
Yeah, that's a filed document that is recorded with the county, and we could definitely provide that.
Okay, that was what we're looking for, so.
Thank you. Anything from the commission members?
I just have one.
You got to get into the mic or I'm going to get yelled at, though.
Okay, sorry about that. I just have one on your number 6. It says unlicensed vehicles. We can't work on those. This is kind of to help our Menor Nissan dealership. We're doing overflow of cars that I own. So that means I took them in on trade, so they don't have licenses. So if we could just remove unlicensed, because really I own them. Until we resell them again.
I think the important aspect is the junk or dismantled. I
Yeah,
know
I'm
that
not-
this is,
we're
this
good
is
there.
a more recent issue, that the licensing can be problematic. So I'm okay unless the law department has something else they want to add with regard to that.
It's basically my inventory. So like if we're doing a used car that I took in on trade and I need to do the inspection or whatever on that, then obviously that car's coming over without a license on it. I do own it because I took it in on trade, but it doesn't have a license. So that's the only thing that I question. Other than the other 6 or 10 things, I'm fine.
I think the question is whether or not this therefore then becomes a storage yard. And obviously the conditional use permit would be for a repair facility. Is it associated with the dealership? Yes, but it's going to be treated as a standalone repair facility. I think to the gentleman's point, it might be an unlicensed vehicle, but it's there for work. So be it. That if this conditional use permit is issued, would be consistent with those provisions. If it's just going to be for vehicle storage, it does seem then the application is for a materially different use.
There is no storage there.
Okay, thank you.
Mr. Chairman?
Yeah, Mr.
There
Burke.
there was a letter that was sent to us. It was applied to this project?
Yes.
And, oh yeah, there it is. And it was talking about the condition of the building.
I spoke with the chief building official. He has no record of any particular issues, and we don't have any knowledge of any problems with the building. Maybe the applicants can speak to. I would imagine he would have inspected it before purchasing or leasing it, if there's any concerns.
And it'll have to be inspected and permitted
Right.
during renovation.
Yeah, we have done substantial work in that because it was vacant for a long time. We're putting a new roof on it. If anybody's driven by lately, we've painted it, we've cleaned it up, it'll be according to what my standards are.
And the building
I don't think
department.
that, yeah, and I
Right.
don't think that'll be a problem.
I only brought it up because it said the building would want to be demolished or something. That was not
Right.
fixable. I just
Right.
thought I'd address the letter. Okay.
Anything else?
Mr. Chairman?
Mr. Tiedemann.
One of the conditions is to restripe the parking lot, but that parking lot is in really rough condition. Were you going to do any repairs to that?
Well, my people are looking at it now. Right now, I also own the 2 Infinity stores, so they're working on those lots. So
I'd really
yes.
like to see that parking, I mean, it's just cracked and patched and crumbling everywhere, so love to see that get taken care of.
We're gonna. It'll look like Menor Nissan.
Yeah,
I
and which
won't
is-
make it concrete, but I will put it to our standards of what we believe it should look like.
Thank you.
That's not a problem.
Thank you. Is there anything else?
Do you want to modify that condition to make sure that it says
Sure.
repaired, striped and repaired?
That'd be great.
And do we want to modify number 6 on the or unlicensed?
Just remove it.
Yeah.
Just no junk or dismantled motor vehicles.
That's perfectly fine with me.
Anything else? With that, I'll entertain a motion.
Motion to approve with 10 conditions as modified?
Second?
Jackie, please call the roll.
Mr. Tiedemann?
Yes.
Mr. Varga?
Yes.
Mr. Crocker?
Yes.
Mr. Hadden?
Yes.
Mr. Perkovich?
Yes.
Mr. Cook?
Yes. Thanks.
Thank you.
Yes.
We have no old business, and under new business, we have a miscellaneous review to transfer a conditional use permit at 9423 Menor Avenue. Is that applicant here? Please come up, give us your name and address, and tell us a little bit about what you'd like to do.
My name is Octavia Scott. The address is 9423 Mentor Avenue, and I'm doing a child care center. 24-hour child care center.
Okay. Thank you. Kathy, anything from the administration?
Mr. Chairman, we have the conditions noted, and we've also referenced, which the applicant did provide, but I provided an unmarked copy of the Ohio Department of Job and Family Services Child Center rules for evening and overnight care for a licensed child care center. If this is approved, I would recommend that this be attached to the CUP.
Okay. Thank you. Anything from the commission members?
Mr. Chairman?
Mr. Varga?
You provided us with a floor plan of the building. It's up on the screen.
Yes.
Everything is either marked as a classroom or as an office, other kitchens and toilets and stuff like that. In a 24-hour mode, where do the children sleep?
They sleep in their classroom.
So they sleep in a classroom. What provisions for their sleeping, how do they sleep in a classroom?
They actually sleep in the classroom even throughout the day. Like when they take a nap from 12 to 3, they're actually in their classroom on cots.
On cots, that's where I was kind of going with
Yeah.
that. And the the fire department, relative to people sleeping in these, during the day it's a classroom, at night it's a sleeping room. They don't have any issues with any additional exit or conditions that might apply to a sleeping room that.
No, I've spoken to both departments, and they've indicated the particular unit in the building is completely sprinklered. And they're comfortable with that. If there were any major changes to the to the kitchen, the fire department wanted to know that. I had spoken with the applicant, and she had indicated there were not. It was going to be used as is, and so they were satisfied with that information.
So that's the situation. The kids sleep on cots with some kind of cushion or mat on the.
On the cot?
Yeah.
No, the cot have, it's just like you ever seen like a dog's bed? It looks like that, similar to that. It does. And it has like 4 legs, and it's like mesh.
Yeah.
So it's like, it's
Okay,
not
that's
like
fine.
on the floor, yeah.
Just a little clarification in my brain, that's all.
Yeah, it's fine.
I was just thinking about this, and so they will sleep in different places in the building. Someone is there 24 hours. They're awake, they're overseeing this. Kids are on cots. Okay. Thank you.
Thank you. Is there anything else?
Mr. Chairman?
Mr. Crocker?
This is a rather unique situation. I've never heard of a 24-hour daycare before, and I know there's a need for it. But do you have any experience running an operation like this or another facility that you're?
I have 2 other child care centers.
Okay.
One is in Richmond Heights and one is in Solon.
Are they 24-hour?
No, we're just open at midnight there.
Okay. Okay. All right. Thank you.
Mr. Chairman,
Mr. Tiedemann?
what is the security like at nighttime especially? Like if a parent's coming late at night to pick up their child, what do they have to do?
Well, the doors are locked even throughout the day.
Okay.
So anytime a parent comes, they have to ring the bell and get let into the building. So it'll be the same way at night. The parents will ring the doorbell, or they'll call in and say they're outside, and then we'll get the kids up and take them to the door.
Excellent. Thank you.
You're welcome.
Thanks.
Is there anything else? With that, I'll entertain a motion.
Motion to approve with the 5 conditions.
Second.
Jackie, please call the.
Wait, you wanted to attach a reference to that state requirement?
Yeah, number 3 does reference C attached. I just wanted to say that
Okay,
for the record.
that's
Yeah.
sufficient, okay. sorry, excuse me.
Jackie, please call the roll.
Mr. Tiedemann?
Yes.
Mr. Varga?
Yes.
Mr. Crocker?
Yes.
Mr. Haddon?
Yes.
Mr. Perkovich?
Yes.
Mr. Cook?
Yes. Thank you.
Thank you.
Thank you.
Number 5, we have amendments to Chapter 1157.02 and 1158.05 of the Mentor Code of Ordinance. Kathy, could you take it from here?
I'm going to defer to the Law Department on the review.
Mr. Zeman?
Thank you, Mr. Chairman, members of the commission. Referred to by the City Council is Ordinance 24-0-072. This is a companion piece of legislation to another ordinance that you've got for your information. You do not make recommendations on 24-0-071. The reason is that's a proposed new business regulation, and business regulations are outside your purview pursuant to charter and code, but they're a little bit related. So we've had a bit of confusion, I want to say 10 years worth at least, relative to the use of short-term rentals within the city of Mentor. When the administration has become aware of someone operating a short-term rental, I'll define what that is a little bit more in a few minutes here. We have always taken the position that the zoning code does not permit that species of use, and that it needs to cease. And so we've had periodic, enforcement activities. Again, I've been around a little while now, so I'm going to say probably about 10 years. Now, it actually is permitted in one and only one zoning district, which is the planned development overlay. It actually says short-term rentals are a permitted use in that district. As you know, currently only the former Bolton property is zoned under that under that overlay classification. So, and anywhere else in the city, it is not a permitted use. One of the things we've experienced, though, is that persons often in good faith don't quite understand zoning. And the reason is zoning's a little bit different from your typical law. Your typical law says, don't do this, don't do that, zoning's a little bit different than that. Zoning says, here's what you can do, and here's what else you can do, and that's it. So, because otherwise you'd have to have a zoning code which, tries to define 1 million some uses and, what you can or can't do. It's just not written that way. So they're written in terms of what is permitted, what is not permitted. So, but that's a legal nuance that can confuse people, and so we'll often see people opening up bakeries in their houses or a retail store in their garage. I really had one of those. Everything in between, contractors, running their business out of their garage. It's sometimes in good faith, sometimes in blatant disregard of what they know they should not be doing, and so it's just normal part of day-to-day enforcement is those types of code issues. Short-term rentals are no different. We think that some people have, in good faith, thought that it's just like renting a house, as opposed to it being a commercial use, more analogous to renting of guest rooms in a hotel. So the new business regulation would basically just clarify in a very unambiguous way that short-term rentals are not permitted in the city. Council is reviewing it in terms of, does that mean that they should also be eliminated as a permitted use in the PD, Planned Development District? And so that's the reason it was referred to the Planning Commission, is to see whether or not those district regulations should be amended to strike short-term rentals as a permitted use. So that's one aspect of the recommendation that Council is seeking. The other recommendation is sort of a housekeeping item, and this is been around, I think, 20 years now, a little bit over. So this has always been a curiosity, which is renting of rooms is a conditionally permitted accessory use in a residential district. No definition for that term. In 20 years, I can remember one person seeking a conditional use permit, and they were just, basically just being a good resident. And they didn't really require it. They just had a roommate, and they thought having a roommate in and of itself, was renting of rooms. It's archaic, and so my best interpretation of it is that, it's the old boarding house model where someone's renting rooms, and they don't really truly they're not living in a family unit setting. So it's not intended that, you know, if you're living with your significant other or a friend or whomever, in a common household, that's not renting of rooms as we've classified it. So it's archaic. We don't really understand how it gets applied, and so as a housekeeping item, the suggestion is to strike that as well from the zoning code. In terms then of what is a short-term rental, simply stated, it's a transient guest room rental. So same as a hotel. What's the difference? Hotels are more than 5 guest rooms. They're licensed by the state. The state has different classifications for them. It could be extended stay, a residence inn, transient hotel. There's also something called SRO facilities, which is getting a little too deep in the weeds for us. They're licensed. Obviously, we don't permit them in residential districts here in Mentor. We have specific zoning districts in which hotels are placed. Primary difference, though, is that when you're renting a guest room in a hotel, you do not have, as the renter, a leasehold interest. That is not your place of residence. You are not subject to Ohio landlord-tenant law, such that if you fail to pay, in other words, you hold over in your rental of the room, that they would have to then forcibly evict you, filing an eviction action. Right? You have no leasehold interest that can be protected in that way. A short-term rental is exactly the same. The difference is it's 5 guest rooms or less. It can be part of a house. It can be the whole house. You can have an apartment and try to utilize that as a short-term rental. I'm sure you're going to violate your lease, but again, there's nothing. We're looking at dwelling units in terms of what we're looking at for short-term rentals. So again, akin to that, the state does not license short-term rentals. It just doesn't have any regulatory scheme for them. Instead, it leads that up to local jurisdictions. The state does permit them to be taxed under the lodging tax. You have to amend your lodging tax to do that. Mentor has not done that. They're not permitted, and so just haven't done that. Other communities that do permit short-term rentals have also amended their lodging tax, which is a maximum of 3%. That can be imposed by an Ohio municipality, as well as other licensing schemes, so that health and safety issues are addressed, as well as other practical issues. In Mentor, we have a residential rental code, and before I enter into a lease as a tenant as a landlord and tenant relationship, we're required to get a certificate from the city. They go through real common sense things, making sure that the fire detectors are all operational, things of that nature, to make sure that they can be rented consistent with health and safety. We have no such regulations in Mentor, and so all of those are obviously of concern. Why the Planned Development District allows for short-term rentals when we have no companion regulations, I really don't know the answer to that. I think it was just an error of omission on the part of an outside consultant that helped draft those regulations. So it's something that just became of note during this process. So as a housekeeping item and as a companion piece, that's in front of the Planning Commission for recommendation. I do have some additional commentary, which is that during the course of Tuesday's council meeting, there was a really great debate, frankly, if I may editorialize a little bit. We've got some persons that own properties in Mentor, and they utilize their public speaking time to sort of make the case that these actually short-term rentals could be a beneficial use to the city. And the council heard those concerns, and I think one or two during the course of the public meeting actually expressed, well, maybe it would be appropriate for the Planning Commission to undertake a deeper dive and to see whether or not short-term rentals should be permitted, conditionally permitted in certain districts, if at all, what regulations they may be subjected to, and to again, hopefully on its own motion, take up the issue if you so choose. So I'd indicated tonight I would appear at the meeting and just pass that along and answer any questions that you have. Thank you.
Thank you, Mr. Zeman. Kathy, do you have anything?
I'll certainly wait to see what you all have to say.
This is a public meeting, but it's not a public hearing. I know there was some paperwork filled out for people that want to come up and speak. Is there maybe a spokesperson that can come up and speak? And, because I know I watched the meeting on Tuesday, and I'm sure most of us did as well, but is there somebody that would want to come up? Do you have like a spokesperson? Sure, sure. What are you worried here from? It's a public meeting, but it's not, there's no format for a public hearing. So,
Some of us weren't here, the other weren't able to be here in the previous meeting.
Mr. Chairman.
yeah, Mr. Zeman.
Just to be clear, it's a recommendation from the Planning Commission. The difference between a public hearing and a public meeting is during the course of a public hearing, individuals have a right to speak. We have persons before council, for example. They can speak for 4 minutes on issues of concern. Likewise, during the course of the conditional use permits, the code actually states it is a public hearing and persons have the right to voice their approval or disapproval or something in between relative to conditional use permits. So any speakers that the chair may entertain is discretion purely, and just to finalize that thought, the ordinance will still go back to council. Positive, negative recommendations, neutral. It still goes back to council for its final reading prior to city council acting on it. And again, pursuant to council rules, persons have 4 minutes to give a presentation as persons before council.
Okay,
Thank you, sir.
thank you.
I guess I have a question for Mr. Zeman. With that, if, as you indicated earlier, if the planning commission wanted to make a motion to do a deeper dive, as you say, and explore possibly looking at ways to not do an outright ban, but allow for them, but with some restrictions, how would that impact what is happening at council?
Ordinance, sorry, I don't have my glasses on, I cannot read anymore. So, Ordinance 071, which is the business regulation, council can act on. Ordinance 072, council has to wait for the planning commission's recommendation. So if you were to table it tonight because you want to consider it, in greater detail, then council would not act on the zoning code amendment. It can still, however, act on the business regulation. That's really just in front of you tonight, just so you understand globally why Ordinance 072 sort of fits into that scheme.
Thank you. So you drew the short end here? Give us your name and address and.
Appreciate you. My name is Jake Bolanek, address at 9260 Jordan Drive, Mentor, Ohio. Do I also follow the 4-minute rule at council? We'll play it by ear.
We'll play it by ear.
I appreciate you. I want to first state that I've been a resident since 2019. My wife has been a resident for 29 years. And our care for the city is tremendous. We know it's an amazing city. We wish to share it with a bunch of other people within the city and out. That can include visiting family members that may have moved away to come back into town. We support local residents within the area, providing jobs, including landscaping needs, plumbing, electrical, drywall, cleaning services. So we give back to the local community in terms of that. Taxes are fully changing first of the year for Lake County specifically, so all short-term rentals defined by the state will have to pay a 5% tax fee. Local cities have already taken this into account. Fairport, for example, Men on the Lake, the city capital or the state capital, Columbus, Cleveland, Ohio, all allow short-term rentals on a permit basis with restrictions. I stand in front of you today to consider, on Tuesday, the council did ask to request considering the ordinance 071 in addition to 072. So I stand in front of you speaking towards both of those as they reference each other. But based on the pros that can be offered to the city that we have available to us, I encourage to consider partnering with landlords that may have already been doing this, or other cities that have allowed permits to completely outlaw and ban short-term rentals, which is not defined by the city of Mentor quite clearly. There's no definition. That's why a new ordinance has been proposed to define it. Within current city ordinances, there's no definition. Council has referred to a tourism house. That is not defined even on a state level either. Tourism house has different definitions by every state or every city within the state. Look at Kirtland, look at Fairport Harbor, look at Mentor on the Lake. They all call quote unquote short-term rentals something different. They all define them something different. So to reference a short-term rental in one ordinance is just not, there's no justification to tell residents of Mentor to say they should understand what that means, because there's new definitions all the time. We're coming into a world that's very growing, and the council referenced that roughly 10 years ago is something when this started on a short-term basis. But the times are changing, the need is changing. There's roughly 3 to 4 million short-term rentals within the United States of America. There's a huge benefit to it. In the state of Texas, Austin, Texas, they tried to completely outlaw short-term rentals. Federal judge came back 2 to 3 years later and said that that was unconstitutional based on our Fifth Amendment right. New York, they tried to outlaw them as well. Again, they were not allowed to. They had to permit them on a basis. So to completely outlaw them, I believe there's no justification behind it. In addition, I asked the commission today to think, what started this conversation? Yes, council referenced 10 years ago, but has there been any nuisance properties, any complaints, any issues within the city of Mentor? There's a lot of benefits that can support the city in this reference. And to completely outright ban them, I believe, goes against what Mentor stands for, and that's to support the residents, to support local, to give back and build this city better than what it was yesterday. And if we support it, I believe that's just going to thrive the city of Mentor. And I ask you that we're moving a bit quickly and potentially revoking this right, and to partner either with cities or residents to see what can we do to permit these, how can we regulate them, in addition to how can we get taxes out of it as well as other cities have utilized. I believe there's a win-win for everyone involved, including majority the residents and the awesome city of Mentor. Thank you.
Thank you, Jake. Anything from the commission members?
Mr. Chairman?
Mr. Varga.
And I'll address, I have a question that I'd like the city to respond to. Has there been any basis or series of complaints that are associated with this? Has there been any problems or police calls or other complaints that deal with the fact that this has been going on for a long time?
We through the Code Enforcement Division of the Planning and Development Department, we have received calls. It has, as to Mr. Zeman's point, this has been going on in terms of the confusion of it and challenges of enforcement of it for a long time. And so having some clarity is important, but yes, there have been some calls of concern with them. And part of it maybe is also just having a clear understanding and education of what can and can't be done.
So basically, the complaints have been about the legitimacy of being in a code. Has there been any other types of complaints or problems? Police calls, noise complaints, parking problems, any of those kinds of issues that have come up?
I can't speak to that.
If I may,
Sure.
the few that have reached my desk, it's typically a neighbor that sees something going on next door across the street, and they're like, what's going on over here? There's people in and out, and they realize there's just, they don't understand what's happening. So that usually would go into code enforcement. Earliest one I could think of was probably about 10 years ago. It's not like this has been around forever.
Sure.
So it usually be a concerned neighbor, and it's like, what's going on over here? I don't think that the owners live there, and there's people coming in and out. Now, this is 10 years ago, and this is probably a little bit more of a novel thing. And so code enforcement go out, do some research, and realize it's being used for transient purposes.
But there doesn't seem to have been a history of nuisance issues beyond the
I-
code aspect?
Fortunately, we have not had one of those headline-making incidents that you may have seen in the news. No, we have not had one of those.
Hold on. We're going to get to a bunch of things here. Just hold off, okay?
As far as the city knows, and I've been thinking a lot about this, and this might be a question that the group or a spokesman might answer too. Beyond single-family detached houses that are being used for this purpose, is there any other types of housing being used? Apartments, condos, like duplexes?
Well, we don't know what we don't know. There was a commercial structure on Route 20 that was recently discovered to have been unlawfully converted into a short-term rental. When I say unlawfully, they didn't pull a board building permit to make the modifications.
Oh,
They
that's
just
the
went ahead and
unlawful
did it.
part, yeah, right.
Yeah, not to mention, it's a commercial district. It just wasn't zoned for it. So yeah, typically it's just been a situation where, it's like any zoning violation. You find out because often, some adjacent property owner sees something that doesn't look right. Someone operating a retail store in their garage, and they got packages coming out currently, or people coming to pick up goods or something like that from their neighbor. Construction materials that seem to be piling up on the residential neighbor's lawn, things of that nature. So our code enforcement inspectors are limited in number. They're extremely good at what they do, but they can't be everywhere all the time.
Well, and I would also think that, I'm thinking well, where are the points of conflict? Where does some of this create an issue with the community? I mean, I would think that maybe, all of a sudden, just like you say, the neighbor across the street sees 4 cars show up from out-of-state plates or something, and, they don't know what that's all about.
Well, the conflict is you buy a home in your residential side street. An adjacent property owner, maybe you know your neighbor, maybe you don't. But instead of it being a place of residence, as yours is, as everyone else is on the street, as you have, as an owner, have an expectation, instead, now a residence is being used for a commercial purpose. It's being used for transient housing. So nightly, weekly, individuals are leasing the space. How many are leasing it? How frequently? Are all of the rooms being utilized as guest rooms? Is the entire structure being utilized as guest rooms? And now you have a commercial use across the street or neighboring you, and is that consistent with your expectations as a single-family detached homeowner, or as someone who owns a condominium unit or something of that nature? If you go to sell your house, does that cause you any concerns relative to your property value? Because now it's not residents, it's not individuals with leasehold interest. Now you have a situation where the house across the street is being utilized for transient guest accommodations. Does that cause you concern as a property owner relative to the fair market value of your property should you go to sell it? Again, it's a global issue. So what's just because something's good for you as a property owner, and again, it's great for people who are saying, well, I'm going to use my property for the bakery, the bakery, the retail store in the garage, or as I'll run my construction firm out of it. It's great for them, and I understand they don't think they're doing any harm, and they don't intend to do any harm. But the reality is, the purpose and intent of zoning is to, make sure that areas function consistent with how they have been built out, how they're intended to be used, and to preserve, a certain expectation relative to those property owners. And it's the whole reason that, tonight you've got conditional uses. Well, those adjacent property owners may feel that those conditional uses are not appropriate next to their business operations. It's no different. It's to make sure that, the adverse effects are diminished, mitigated when available. And the idea that individuals are going to operate a commercial facility that we don't inspect. So now, if you want to lease your house, you can do that. Of course you can. That's your property right. So you want to lease your house. Under Ohio landlord-tenant law, you're going to enter into a lease agreement. It could be a monthly tenant. It could be a 6-month term. It could be a 10-year term for all it matters. Now that individual, that's their place of residence. They have rights. You as a landlord have rights. But to do that, you have to register that as a rental unit. Our inspectors go in, inspect it, make sure it complies with health and safety standards. Now, say, well, I'm not leasing it, I'm just doing a short-term rental. So I don't have to apply for a residential rental certificate. So the absence of regulations isn't an accident. The absence of regulations is because this is not a permitted use. It is a commercial use, period. That has been the city's position for at least 10 years that I first made an opinion on it, because that's when it first came up for us. So that's not the debate. The debate is not whether it's a permitted use. Now,
I mean,
there could be a fair debate, however, should it be somehow permitted? Now, that's a very deep dive, because, again, you as an adjacent property owner are going to get notified that your neighbor, maybe it's an investor, maybe it's not even someone who has ever lived there, now wants to convert the house across the street from you or adjacent to you into a short-term rental. Should they be allowed to do that as of right, and you have no voice in that? That's a policy question. I don't ask the question to suggest what the answer should be. Should it be a conditional use? If so, what parameters should be set with that conditional use? What rights as you, as the owner adjacent, who takes exception to that, who feels it's going to hurt your property values if this is utilized for some commercial species of commercial use, what weight should be given to your opinion? Should you begin absolute veto authority over it unless you sign off on it? Should there be some middle ground? Should they remain to be owner occupied so that they are only permitted to be used for guest accommodations for limited periods of time, and then have to be owner occupied, elsewhere? Should there be geographic limitations on it? Does it make sense to have it on a residential side street, or perhaps a street which is more of a main artery? Does it make sense citywide? Or are there specific areas of the city where it may seem to fit a little bit better? So there's a really, and we can go on and on and on and on. I don't want to, but as the commission well knows, the policy considerations and the very, very deep dive, if regulations are to be drafted, are going to be time consuming. There's no question about that. So I don't ask these questions to suggest it's a bad idea. I only ask these questions to point out that it's not simple, but just, the one gentleman's correct. You see a lot of variation. On the one end of the spectrum, I think Columbus City Code, there's a department, I don't think it's called the Department of Short-Term Rentals, I don't know what it's called exactly, but you go in there and they've got a giant regulatory scheme, and you pull your permits and they do some inspections, and you're subject to their municipal lodging tax. It's purely an administrative process. Other communities go more of the zoning route, where you have to get a conditional use permit, and there may be pretty substantial limitations on where a permit could even theoretically issue. So you see a pretty broad spectrum.
You mentioned something about, well, let's just say it's a legal question. You could answer this. This is a different classification of occupation of the residents. Is there a limit to how long someone can stay there before their status changes in the law, or is it always just you just ask them to leave, they have to leave. They don't establish any kind of right to the property if they're there for more than 2 weeks or more than a month, or is there? I mean, is there a legal issue here that needs to be defined?
Well, not necessarily for the. I don't want to necessarily answer that very directly, because I may be throwing legal advice out there to someone who may try. So we have a landlord-tenant law in Ohio, right. And there's always some landlord out there who, out of ignorance or malice, tries to circumvent those things. And so If it looks like a landlord-tenant relationship, then it's a landlord-tenant relationship is how I would look at it. So, generally, if you're renting month to month, again, if it looks like a duck, quacks like a duck.
Okay, yeah, I see what you're saying. So if we permitted this, or the city permits this, and they'd have to get a permit or a certification or something, the differences between a rental property, a traditional rental property, and a short-term rental property would be defined in the requirements of the permit or the...
Correct.
So we could create a list of requirements that would separate the two.
Yes.
In terms of how they'd operate.
Yes.
For instance, and I'm not proposing this, I'm just throwing this out. For instance, you could say that you could only use short-term rentals in a detached, single-family residence rather than in a apartment building or some kind of, duplex or some,
Yeah.
just because it's easier to maintain, define. You're not just
Yeah.
as an idea, that could be the kind of, limitations or conditions.
Again, using Columbus City Code on the one end of the spectrum
Yeah,
and another community that I work for on the other end of the spectrum, it's a conditional use permit, single-family detached. It has to be, can't have a detached, garage or anything else of that nature. It's limited with respect to the streets they may locate on. There's a lot of permit requirements. It's subject to annual renewal. So yeah, you see some pretty narrow focuses where it might be appropriate in a community. But the main difference is it a place of residence or not? So if I'll put it, let's give us a case study. If, say, we have a hotel somewhere in the city, and instead of transient guest accommodations, they are now leasing the rooms to people, so that there's a landlord-tenant relationship, and those individuals are now leasing month to month. It's no longer a hotel, it's an apartment building. And we would go in there and say, this is not zoned for residential use. You're a hotel. You're no longer operating as a hotel. You're operating as an apartment building. And rest assured, we would bring an enforcement action to cease that violation.
And I've been thinking, I saw the meeting the other night, so I've been thinking about this for a number of days. So other kinds of limitations or restrictions or conditions would be, for instance, if it's a 3-bedroom house, you can't have more than 6 people living, accommodated by this relationship. If it's a 4-bedroom house, maybe 8 people. If it's a 2-bedroom house, maybe 4 people, or adults, or, so, those are the kinds of regulations that could be put forth to control.
Correct. Yeah. And for example, to make sure that the guest rooms are actually designed and equipped as bedrooms so that you don't have people sleeping in a basement with no secondary egress. Those are the types of health and safety issues.
And they meet the building code, they meet the residential code.
Often a requirement for additional, fire protection, be it, carbon monoxide detectors, things of that nature, going a little bit above and beyond. And then you have to get into the practical issues too. So emergency contact numbers, so that if there is an incident, we're able to get either they're called hosts, so we're able to contact them immediately. We have record-keeping requirements so that we can validate whether or not they're properly accounting for the lodging taxes that their guests are required to pay. They're required to, just like a hotel, the hotel operator actually takes the lodging tax from the guests. They don't pay it. They take it in trust for the city and then remit it monthly. Mm-hmm. So a lot of those details. Often we then have provisions for revocation of the permits. So should there be multiple calls for service? What are multiple calls for service? Disorderly conduct, drunken issues and stuff like that.
Noise complaints, things like that.
Noise complaints, things of that nature. So absolutely. And certainly the advocates that may be using one of these hosting platforms, Airbnb, Venmo, they have their own requirements. But we don't necessarily focus on those. You can take out and add, wherever the heck you want, Facebook or whatever and still operate a short-term rental. So it is, we believe, accurate that the hosting platforms do have some pretty rigid requirements in order to list your short-term rental. But obviously not everyone may want to do that. And there are people out there, frankly, are just looking for ways to get around requirements for residential registration. So you get a mixed bag of property owners out there. But for the people who do utilize those platforms, I think it's fairly accurate that they're fairly rigorous in terms of their requirements as well. But you don't want to necessarily delegate to some internet company your health and your local health and safety. So,
Following that line of logic, could there be a requirement that there be some local management of the facility?
Yeah, the code that we drafted for one of the communities here that I represent does require local contact information, emergency contact information. Should there be an incident, that individual has to be readily available. Yeah.
I mean, we don't want somebody in Hong Kong owning this, and that's the person you call. It should be someone locally who can at least be responsible or take action, for the owner, or someone to manage it locally would seem to be a reasonable requirement.
Obviously, if there's an incident, again, these aren't individuals who have to be evicted, So
I understand.
You rent a hotel room and see what you can get away with over there before they call the police and you're escorted out. When you've got a single family detached, it's a little bit more of an adventure.
Sure.
You don't want a situation where we have to go get a warrant to enter. It's a heck of a lot easier if the local responsible manager or host is required to come out and address the issue.
Mr. Chairman,
Mr. Haddon.
after hearing all this, and plus I did watch the meeting on Tuesday, I think taking Joe's kind of statement that we should maybe take a deeper dive into this and look into this, and before we ban them, maybe get some regulations in place, or may not. Maybe we can't work it out, but at least take a deeper dive into this. I've stayed in short-term rentals and I love them, so I think it's a good thing for the community.
I have too.
Okay. So we can, I know I've been talking a lot, and there might be a game that someone might be interested in there too. So I'll just wrap up then, if I may. Before we leave then, is there any specific guidance, what types of information you may want us to get in front of you to assist you in that process?
Mr. Chairman?
Yeah, Mr. Dieterman.
Question I guess I have is the examples you have given. What we have, to me, this is a commercial use in a residential zoned area. That's why we have zoning, to protect everybody. So if we were to, in the future, say we're going to conditionally allow these, does that open the door to start conditionally allowing that bakery or that contractor who's working out of his garage? Is it going to be a snowball effect with this stuff?
No.
Okay.
Well, thank you, Mr.
I mean, just along those lines, there is a limitation, but there is a provision for allowing someone to work out of their house, as long as the kind of business and the interaction with the public. I mean, I have my own business, or had, and it's registered with the city. And thank you. I paid the fee, but it fell within the allowance of what was permitted, and so it's not like you can't run anything out of your house.
A home occupation is pretty much just a desk in your house. You can't have outside employees. You can't have people showing up to pick up baked goods.
There is a little
Or,
there is a little bit
yeah.
of that permitted with those limits.
Barely any. Again, you can operate a home office, but you are the only person as the occupant who is allowed to man that home office. You can't bring in outside help. You can't have customers or clients come in. So, and you sure as heck can't start selling, out of your garage.
Oh, no.
I know. We got you.
Mr. Chairman?
Mr. Tiedemann.
Thought of another thing. You asked what we might want to know about.
Yes, sir.
And now I'm losing my train of thought. I'll come back. I lost my train of thought.
Thanks.
Well, the only other
He
thing.
didn't.
I know. It's a long time before the caboose goes by. I keep looking at where the points of friction might be with the community, you know, if this is allowed or if there's some provision. Parking, I would think, would be one of those points of conflict. All of a sudden, people are parking on the lawn because there's not enough room on the driveway or there's not enough parking space. I mean, that's kind of one of the things I think would have to be controlled. Because just like, you know, the person across the street looking out their living room and all of a sudden 6 cars show up and they're all over the place, right? There's no overnight parking on the streets, and so where are they gonna put all those cars? So that's a limitation to what could, in my mind, that what could go on there to the point where it would be in conflict with the rest of the neighborhood. That kind of thing has to be regulated.
Right. Yeah, for example, the code that another community utilizes that I work for, you know, modifications in furtherance of that use aren't permitted. So you're not going to have any parking that you couldn't have as a single-family residence, for example. Other types of modifications they're not permitted. It needs to still look exactly like any other single-family home.
And I think the only real requirement for single-family homes is, what, 2 cars, 2 spaces, as a rule?
It's actually a
Well, you
Minimum, I mean, all I'm getting at is that
One
there could,
closed,
there
yeah.
could be, there could be a limitation placed on this kind of activity that might make parts of the activity not feasible. You know, if you're looking at people coming from out of state and different places, and there are multiple parties, like what I've been familiar with, you might have 3 or 4 cars. That could be a problem with the existing requirements for parking for residents.
I think it's all in how you write them.
I understand. but
Because,
that's-
you know, I'm
but that's-
sure, to speaking to your point, that you've been in them, you've been in them, I've stayed in them. I mean, you can, I mean, my guess is, I know for the ones I've stayed in, they were phenomenal. And you had a parking spot, everything was locked. I mean, they had it
Right,
down to a
right.
science. And there's a reason for that, and that's probably because of partially the local regulations.
Right, right. Okay, that's it.
Mr. Chairman, I have a question. Maybe this is for the administration or Joe. If we are sort of leaning toward, let's giving it a little bit deeper dive, beyond tonight, if we have a list of ideas or something, how do we get that, or what's the proper procedure to get that to you or administration?
Email, call. Generally, you know, if someone say, you know, find us a you know, you mentioned Columbus City Code. Can we get a copy of that? You mentioned some other code that was recent. Can you get a copy of that? Got some issues and concerns. You know, then you know, we go out to just do some research and get you whatever resources that you might be interested in.
Okay, thank you.
We do have a handout from the American Planning Association. They did a nice planning advisory service memo on short-term rentals, and their example was actually New Orleans. And it really laid out in great detail how they regulate and procedures. So it's just food for thought. It's just something to look at in addition to some of the ideas and suggestions that Mr. Zeman had with some of the other cities. When we ever do any kind of research, we always start with the American Planning Association. So it's a nice publication, and it's just, again, just some food for thought. So we have something to look at.
Thank you. Thank you.
I think that this is, I need to put a lot of thought into this. We want to be small business friendly, but I'm torn between the CUP and administration level. And Joe, you brought up a good point, that, you know, you want to give the people on the street that live there with the expectation a voice, a public voice in these meetings. So I just think right now, I'm for them, but with restrictions. What they are, I don't know right now. I think we should take a deeper dive into this. This isn't a 20-minute conversation. This is a business model that's booming everywhere. So that's my 2 cents.
That triggered my thought back, and that, it was the adjacent property owners that, when you buy a house, you don't think you're buying a house next to a quote-unquote short-term rental. And so what rights do the adjacent property owners have, or do they just lose their rights? I think that's something that needs to be considered.
I do too.
It's almost like how much weight legally should be afforded. And the commission's familiar on some of the conditional use permits, the types of conditional use permits. You'll see additional, considerations, additional performance factors. So it kind of raises an interesting legal issue. I'm not going to answer it anytime soon, which is, should an objecting adjacent property owner potentially have a greater weight in that process? How much? Veto authority versus, it's just one factor among many. It's obviously a very, very difficult question, and particularly someone's owned a home for many, many years. Now the rules change, and how is that consistent with their expectations?
Thank you. So what's the pleasure of the commission here?
Well, I suggest we table this for further investigation, for further information.
I would agree with that.
Is that a motion? Second?
Second
That's
it.
a motion, yes, second.
Jackie, please call the roll.
Mr. Tiedemann?
Yes.
Mr. Varga?
Yes.
Mr. Crocker?
Yes.
Mr. Haddon?
Yes.
Mr. Perkovich?
Yes.
Mr. Cook?
Yes. So in the next coming weeks or so, we'll get some information and reach out to Mr. Zeman with any ideas, and we'll try to work through this. Is there any platform that we possibly have a work session on this at all, or is it all done here?
You can call a special meeting, perhaps.
Okay. Well, we'll think about that. Okay.
Commissioner, may I ask a question?
Sure, come on up. Jake, right?
Jake, yes.
All right, come on up.
Beard from State Farm. My question is, will there be access to this meeting from the public point of view where outside counsel can be provided? From our understanding as landlords or residents, counsel had a lot of great points today on the legal aspect, but I don't see his specialization in real estate housing. In a point in cases, he mentioned Venmo as a type of rental platform. Venmo is a payment platform. So the credibility there, I see he has a lot of good points, but deferring everything to the council here, I question, and so I ask if there's a specialty outside source or us residents can be utilized in helping format these permits, because we would love to be part of the conversation. We agree a permit system should be in line, similar to long-term rentals, that are 12 months or in our case defined as 30 days or more, I guess. So we would like to be a part of that conversation to assist and see where it goes from there. And residents are absolutely important. I actually have a signed document of 4 residents around my rental property when I submitted for a cut permit during council's recommendation. They all support it. Every single resident in my area supports it. So if there's a concern of residents, I believe that should be explored as well, as there is support between these in regards. So again, back to my original question, if there would be a seek for outside specialty in this matter.
Well, I think ultimately the planning commission's role here is a positive or negative recommendation to city council, and they will act on it.
Okay.
And at that point in time, you would have another a chance to speak.
Thank you.
But also, I don't think we're concerned with the property owners that leave game 3 to come here and speak. It's the ones that aren't here,
Sure.
right? I'm sure all of you are fine. That's why you care so much.
Mm-hmm.
It's the people that aren't coming to this meeting that have the rentals as well. And that's what we have to look out for. So it's more than just a 10 or 15-minute item number 5 on the agenda. So
Sure.
I think we're going to take a deep dive into it. And like I said, I'm for the small business. I use these things too. So, but I just think that we don't want to jump in wholeheartedly and ban them all together, or just come up with something really quick.
I
So
agree.
I think we need to, and this is gonna be an ongoing process. But I do thank you for your input. Thank you.
Yeah, thank you for listening.
Yeah. Kathy, anything from you?
I was just going to ask if Mr. Rastetter could pull up one of the documents that's on the laptop. Oh, that's right, you, never mind, it's okay.
That I'll entertain a motion to adjourn.
So moved.
Did he lose
Second.
his laptop again?
Do we have a second?
No.